Hi, this is Sarah Root, and I'm representing Shawnee Mission School District today as I explain your parental rights covered by IDEA in the state of Kansas. Parental rights have been around long before the United States was established. For example, John Locke, who his political philosophy significantly impacted the American Revolution, the Declaration of Independence, and even our Constitution. He's one that penned our natural rights, our life, liberty, and property. It was Thomas Jefferson who then added the pursuit of happiness instead of property. He penned, parents have the authority to govern their children. And that right was supported by the framers of the Constitution, and is something that they believed in, and it set the foundation for parental rights in the United States. There have been, in the past 100 years, there's been some significant Supreme Court cases that set precedent, giving parents the right to decide what is best for their children. The Individuals with Disabilities Education Act, which was reauthorized in 2004, is also known as IDEA, and it includes important procedures for special education evaluation and eligibility, IEP development and implementation, and resolving disputes. So those procedures are what we call procedural safeguards, or the parents' rights, or parental rights. And this helps the schools and parents work together to create an effective educational program for children with exceptionalities. So Supreme Court case Hendrick-Hudson Central School District versus Rowley ensures the importance and need for procedural safeguards. So I'm going to review the Kansas procedural safeguards that we use here in Shawnee Mission School District. First, parent participation is incredibly important for your child and also to us at the school district. The parents are part of the decision-making team. This is a collaborative team effort, and we need the parents' input in order to make sure that that IEP represents them, because it is individualized to your child in your student. So under FAPE, which is a free and appropriate public education, every child with an exceptionality is entitled to FAPE, and they are provided this under public supervision and direction without charge. They meet the standards of the state board, include preschool, elementary, and secondary education, and they are in compliance with the IEP. So special education must meet those criteria. Procedural safeguards. So part of that also is the notice of meeting. Parents are provided this, and it's related to the eligibility, evaluation, reevaluation, IEP development, and also the provision of FAPE, or the educational placement at school. Also part of the procedural safeguards is an insurance that there's reasonable effort for the parents to understand what is going to happen at the meeting, or what is happening at the meeting, and that includes alternative communication opportunities, so they can participate through the phone, through a video conference. Here in Shawnee Mission School District, we use WebEx, or through a conference call where everyone maybe meets in a meeting room and we're all on a call and the parent might be on the other end. They also have a right to an interpreter. So if they're deaf or need sign language, or if they speak a native language other than English, we will provide an interpreter to ensure that they understand what is happening. The definition of a parent in the state of Kansas is a parent that is biological parent, an adoptive parent, a person acting as a parent, such as a child living with a grandparent, they could be the parent, legal guardian, officially appointed education advocate, or a foster parent can also be appointed as the educational decider. The educational decisions made for that child are made by the parent. So to ensure parents have knowledge about their rights, under IDEA, schools are required to provide a copy of the parental rights in the special education notice. This is one time per school year at least, usually at the IEP meeting here in our district, and also when there's a referral or a parent request for initial evaluation, the first formal complaint, change in placement from disciplinary removal, or upon parent request. So one of the procedural safeguards is a prior written notice, otherwise called a PWN, and this is the proposed actions that the school is initiating or changing, and that includes identification, evaluation, educational placement, provision of special education and related services, or FAPE, or if the school refuses a parent's request. Again, they have to make sure that the language in the prior written notice is understandable to the general public, so anyone who can read it and understand it, and also provided the native language of the parent. So parental consent is the parent must agree in writing to the actions within the prior written notice. So they must agree in writing to the carrying out of the activity, wherever that is. And they must, again, be informed consent, fully informed. They know what has happened. It's provided in their native language. And that they also should know that their consent is voluntary. It may be revoked. That revocation is not retroactive. Parental consent is required for pretty much everything, but there are some instances when parental consent is not required, and that's to if they decide to review existing data for this student, to give an assessment that all students are taking, or if there's minor changes but nothing that do not affect services or placement, or if the school refuses to conduct an initial or reevaluation. So the school must take steps to ensure that one or both parents are able to attend the IEP meeting, and that is done through a notice of the IEP team meeting, and it has to include the purpose, time, date, location, titles and position of the people attending. Under special circumstances, there could also be a Part C coordinator. And then when the student is 14, the notice must indicate the transition and post-secondary goals will be reviewed. The school will also make sure the student is invited, and there could possibly be an other agency representative, such as someone from the Division of Voc Rehab. And the parents can invite others to the meeting. So if there's a grandparent that's influential in that student's life, they can come as well. At the age of 18, the student becomes their own educational decision maker. So the student is the one to sign the informed consent, and they're the ones required at the meeting. Parents are not entitled to attend the IEP, however, can still be invited, and it's usually encouraged unless the student doesn't want them there. Unless the court has ruled the student cannot fulfill the responsibilities, then the court will order the parent to become a legal guardian, and then they will again be the ones that are signing the informed consent. If you have any questions about your parent rights, you can check out all these different resources. Families Together is an important one. It offers training and information and resources to parents. Definitely in our district, they're wonderful. We work with them all the time. And if you have any questions, I encourage you to reach out to your case manager or the special education department at the district office. And these are my references. Thank you so much.